Missouri just fired a legal warning shot heard across the country, bringing back a gun rights law that lets citizens sue cops for enforcing federal firearms rules. It's bold, it's controversial, and it could change how local law enforcement works with the feds, if it survives the courts this time. What's up, everyone? This is Ted from Line 45, and today we're diving into the bill that's shaking up Missouri's gun politics, where enforcing federal gun laws could cost local cops 50 grand a pop. Before I start, I would really appreciate it if you would push those buttons below, the subscribe button, the notification bell, all of them. This is not necessary, but those little clicks help a brother out. Plus, it pushes me to give you more valuable content on your screen. Now, buckle up, and let's get back to the video. You know how sometimes a bad law doesn't just die, it comes back meaner, sharper, and way more targeted. That's exactly what's happening in Missouri with House Bill 1175. The original Second Amendment Preservation Act, passed in 2021, had plenty of bark, but it got shredded by federal courts in 2023. This new version? It's been retooled to do one thing: keep Missouri cops from enforcing federal gun laws that go beyond what the state allows. Now, let's be clear, this isn't a nullification bill. Lawmakers got smart and rewrote the language. Instead of declaring federal laws void, HB 1175 focuses on restricting the actions of state and local law enforcement. That means if the ATF wants help from your county sheriff for a gun raid, SAPA says, not unless it's Missouri law you're backing. I've talked to folks who train with law enforcement and run FFLs across Missouri. Their biggest takeaway is that this bill is designed to send a message without throwing out the Constitution. Whether you agree with it or not, it's one of the boldest moves any state has tried since the feds started pushing harder on gun control enforcement. This new SAPA is leaner, more calculated, and laser-focused on enforcement. It's not about speeches or slogans. It's about whether your local cop can legally back up the ATF without risking a lawsuit. And that takes us into something even hotter, which is money on the line. So, how does this bill let Missourians hit law enforcement with $50,000 per violation? When I saw the civil liability clause in House Bill 1175, it jumped out fast. This bill doesn't just tell local police to back off federal gun enforcement. It attaches a price tag. Under this new version of Missouri's SAPA, any Missouri resident who feels their rights were violated by a local agency assisting with federal gun laws can sue. And if they win, they're entitled to $50,000 per violation, plus attorney's fees. No sovereign immunity, no legal shield for departments. That's not just bold, it's dangerous ground for law enforcement. A single joint raid involving a local officer and the ATF could open the door to multiple civil suits. And these aren't symbolic penalties. We're talking real financial exposure for departments already stretched on budget and liability insurance. Lawmakers claim this accountability measure ensures the law is followed. But what it really does is create hesitation. A sheriff in rural Missouri now has to think twice before sending deputies to support a federal action, even if it's targeting violent crime. I've worked with gun shops that rely on federal license partnerships and NICS compliance. This complicates that relationship. Nobody wants to be the department that ends up in court for doing their job with the wrong badge in the room. Supporters call this protection. Critics call it weaponized litigation. Either way, it's a legal tripwire built into the bill that gives everyday folks teeth and turns local PDs into legal targets. Now, it's worth checking how the ATF responded when this same strategy was used back in 2021 and why they're bracing for round two. When Missouri's original SAPA took effect in 2021, I had friends in both local law enforcement and FFL circles calling me, saying things felt off. It wasn't chaos, but it sure wasn't business as usual. The ATF got cut off from the usual back channels they relied on for multi-agency work. Joint operations with local cops got shelved. Task forces targeting violent offenders and straw purchasers slowed to a crawl, all because Missouri police were worried about legal blowback. The ATF didn't stay quiet about it either. In a sworn affidavit filed in federal court during the SAPA challenge, they stated plainly that the law damaged their ability to do basic investigative work in Missouri. They pointed to disrupted access to shell casing databases and delays in information sharing. Local agencies, out of fear of getting sued, started pulling out of collaborative operations. That meant slower investigations, fewer seizures, and some federal enforcement plans falling apart before they even began. This is where the friction gets real. On paper, SEPA isn't stopping federal agents from doing their job, but in practice, it's stripping away the partnerships that make enforcement effective on the ground. And when that kind of support disappears, especially in gun trafficking or illegal modification cases, the ATF has fewer tools to work with. Missouri's reworked bill is trying to avoid past legal issues, but the federal reaction will likely be the same, which takes us right into the next problem: how this law is boxing in local law enforcement across the state. I've sat across the table from sheriffs and task force officers who aren't anti-2A in the slightest, but they're getting squeezed hard by this kind of legislation. With House Bill 1175, it's not just a policy preference. Missouri law enforcement is being told they'll be personally liable if they assist in enforcing federal gun laws that Missouri doesn't agree with. That's not a policy debate anymore. That's career-ending exposure. Police chiefs from Columbia, Ellisville, Rolla, Branson, and more have all gone on record opposing SEPA's return. Not because they want to enforce every ATF policy, but because they know how deep interagency work runs. The drug busts, the human trafficking takedowns, even the gun-running operations, they're usually a combined effort. SEPA throws a wrench into that. If you're a cop in Missouri and the ATF wants backup for a house serving illegal suppressors or unregistered SBRs, you now have to weigh: do I help and risk a $50,000 lawsuit, or do I walk away and possibly let a violent offender off the hook? The Missouri Law Enforcement Legislative Coalition testified that this bill threatens public safety and legal stability. One of their biggest concerns is the chilling effect. Good officers hesitate, and bad actors find cracks in the system to slip through. That kind of uncertainty isn't just a legal risk, it's operational paralysis. And that leads us into the bigger picture: how this entire standoff sits right on the fault line between federal supremacy and state sovereignty. And that's where this fight could go national. I've followed a lot of gun legislation over the years, but SEPA is one of those rare laws that actually triggers a constitutional knife fight. Missouri's 2021 version of the Second Amendment Preservation Act was struck down because it violated the Supremacy Clause. That's the part of the U.S. Constitution that says federal law trumps conflicting state law. The federal judge didn't mince words. Missouri can't tell the feds what they can or can't enforce, and it can't block its own officers from complying without stepping out of bounds. That's why HB 1175 is different, or at least it's trying to be. This time, lawmakers didn't try to declare federal laws null. Instead, they're saying Missouri's cops simply won't assist. The difference might seem subtle, but it's everything in court. They're banking on anti-commandeering doctrine, which is a legal principle that says the federal government can't force state officials to enforce federal law. It's been upheld before in cases like Prince v. United States. But even with better framing, the tension remains. Critics argue that once you attach a $50,000 civil penalty and override immunity protections, you're not just opting out. You're creating an obstacle for federal law enforcement. That's where the courts may once again step in. I've watched how these legal doctrines play out, and this one's heading for a rematch. The moment this bill becomes law, if it passes the Senate, it's likely to get challenged again. And that brings us to what matters most for everyday gun owners: how this thing might affect us directly. Now here's where it gets practical. I've talked to a lot of Missouri gun owners, collectors, folks with SBRs, guys who reload their own .223. And this bill raises one big question: what changes for us? The truth is, SEPA doesn't make federal gun laws disappear. If you've got a suppressor that isn't properly registered under the NFA, that's still a federal crime. What SEPA does is tell Missouri law enforcement they can't help the ATF come knocking. But, and this is important, it doesn't stop the ATF from doing its job. They've got jurisdiction, and they're still going to run their own enforcement. What's different now is that your local sheriff's office might not be riding with them. So if you're being investigated under federal rules, you might not see the usual joint task force operation with city or county deputies showing up. That's the practical impact. For law-abiding gun owners, it doesn't mean much changes day to day. Your concealed carry permit, your FFL transfers, your compliance with Missouri's law, those all stay the same. But where it might matter is if the feds start pushing new gun control from Washington. Red flag laws, mag bans, redefinitions of frames and receivers. Anything federal that Missouri doesn't mirror could hit that SAPA firewall. So no, this bill doesn't make federal law vanish. But it could carve out a space where Missouri gun owners have more daylight, at least on paper, between themselves and aggressive federal enforcement. And that leads us right into where this could all go next. Now that we've seen how deep this thing goes, it's time to call it for what it is. House Bill 1175 isn't some symbolic gesture. It's a direct move to reshape how gun laws are enforced in Missouri. Whether that's a win for liberty or a recipe for courtroom chaos, depends on who you ask. From my side of the table, someone who owns, shoots, and deals with compliance on the regular, it's a bold move that could either reinforce state power or collapse under its own legal weight. The idea of protecting local gun owners from federal overreach sounds good, especially when you've watched regulations shift at the stroke of a pen in D.C., but this kind of law also ramps up risk for your local police, muddies interagency coordination, and makes Missouri a legal test case for every other state watching on the sidelines. If this passes the Senate and the governor signs it, lawsuits are almost guaranteed. Federal courts already crushed the 2021 version. Whether this tighter language holds up remains to be seen, but you can bet the Department of Justice and ATF are watching. As a gun owner, this kind of bill raises more than a flag. It raises questions. Can states draw hard lines without breaking the constitutional map? Can we enforce rights without breaking partnerships? Missouri's betting it can. One thing's for sure. If this becomes law, it's not just going to affect politicians. It's going to affect how law, power, and firearms interact on the ground. And that fight is far from over.